Welcome to Law Easy. My name is Marty Shenkman. We're going to talk about what you need to do when a child, and it doesn't have to be only a child, but we're going to call it a child, becomes an adult, usually age 18, but some states may have different rules. When a child is under 18, they're not an adult legally, you as a parent or guardian can have authority to make decisions and take actions for them. You can see their medical records, you can converse with doctors, etc. Once the child turns age 18, or whatever the age of being an adult, in legal terms they sometimes call it age of majority, you no longer have those rights. Kids going off to college, they just turned 18, what do you need to do? So first, get a durable power of attorney for financial matters. That is a document that in which the child gives you the right to take care of financial, legal, and tax matters for them should they be away. Very important to do. The word durable is a legal term. It sounds kind of goofy, but it's very important. Just because of the historical development of powers of attorney, if you don't expressly state in the legal document that the power shall remain valid in spite of or regardless of the principal, the person doing it, in this case the child, becoming incapacitated or disabled, the power will become invalid at that point. It also, by the way, becomes invalid at death. Just a legal quirk, but make sure that the language used in your document comports with the state law in the state where it's going to be done. So child turns 18, they need a financial power of attorney. Next point, you need to get the child to do at minimum a health care proxy or medical power of attorney. It's known by several different names. The point is it's a legal document in which the child authorizes you to be able to talk to their doctors, their physicians, make medical decisions for them, access medical records, really critical. I just had a tragic situation where someone I know had a daughter who was in a terrible traffic accident across the country. The daughter had reached the age of majority, and when they flew down there, obviously, heartbroken, sickly, worried to help their daughter, there was nothing they could do. The physicians couldn't talk to them. I don't even know how it eventually got resolved, but you don't ever want to be in a position like that. Not for your sake, not for the child's sake. You want to be able to help. So once the child turns age 18, at minimum, get a financial power of attorney, get a healthcare proxy. Another point to consider. A lot of people set up trust accounts for kids in Trust 4, Uniform Gift to Minor Act, UGMA is the acronym, Uniform Transfer to Minor Act, UTMA. Take a look at all these accounts and see when they end. They may end when the kid reaches the age of majority. Some may end at 21. Some it'll depend on whether you make an election to extend it. If that account ends and your child has already reached the age where it has to end, the money should be turned over to the child. You really shouldn't be keeping money in an account like a custodial account past the time that you're legally allowed to do it. It's sort of an odd result. Also, take a look at 529 plans and make sure they're being used appropriately. Thank you for joining me at Shenkman Education. Please keep in mind that all the videos are for educational purposes only.